So hello everyone, welcome again. It gives me great pleasure to welcome Professor Guido Governatori. So pardon me if that is not the right pronunciation. Who is the next speaker? So Professor Governatori received his Ph.D. in basically legal informatics from the University of Bologna in 1997. He has held academic and other positions at Imperial College London. Then there is Griffith University, Queensland University of Technology, the University of Queensland, NICTA, etc. His research is interdisciplinary and focuses on the use of logics and formal methods, techniques for applications in the real world, especially in the legal domain, business process management, and multi-agent systems. He has published over 300 peer-reviewed contributions, including 12 book chapters, 63 journal articles, 252 conference papers, and 25 editorial works. In 2015, he won the Australian Computer Society Computer Science Researchers of the Year Gold Award. And in 2017, he received the Business Process Management Test of Time Award for the most influential paper in the field of business process management. He received funding grants as CI from ARC and EU, as well as other funding agencies, and he has worked in several projects funded by industry or government partners. He has served as program chair at many prominent conferences, including ICAIL, Zurich's Dion, and others. He is also the co-chair of the OSIS Legal Rule ML Technical Committee for the creation of a standard for representation of legal documents. So in this talk, he will be walking us through an interesting topic with title that says, digital legislation. So Professor Governatori, it's up to you. It's over to you.
Thank you. Do you see my screen?
Yes, yes.
Okay, well, thank you very much for inviting me and for this presentation. So today I'd like to present the work we have done on digital legislation. So let me start with the main motivation. So what we want to do is, well, essentially to develop some technology, so computer-based technology, to identify and reduce the regulatory burden and to help government, business, and individual to comply and spend less time on compliance-related activities. So now, so well, what is the general idea and what is the vision behind our proposal? Well, first of all, what we want to do is to be able to regulators to start writing and starting publishing legislation in a digital format, in a machine consumable, and more precisely, in a machine processable techniques. Now, if we have that legislations are available in a format that that can be processed by computers, well, then what we can do and what agencies and governors can do, they can analyze them, they can identify what are potential sources for red tapes, they can do really accurate impact analysis of the legislation and possible changes, and then they can speed up the delivery of services to the public and to citizenship. And then essentially you can achieve more agility. Now, however, if legislations are made public And in addition to the legislations, you have, let's say, a set of APIs, a set of interfaces to interface and to consume such legislation. Well, then there are opportunities for third parties to exploit their legal knowledge, their domain knowledge, and to build a market for digital legislation. So what you can do, external companies, they can provide their insight about a piece of legislation and consume the rules provided by government to create applications, and then this will reduce the cost for justice and the cost for legal services. Now, on the other side, since the legislation are released in a digital, understandable, and processable way, then essentially you have a full explainability of the decisions. And this was something discussed in the previous presentation by Liria. Okay, so let's see how to do it, and let's see what is the general problem we want to address. Well, as you know, and you can imagine, compliance is very difficult, and there are many sources, and sometimes they're also on purpose why it's complex. Well, in some cases, we might have multiple levels of legislation. So we might have a federal, state, local. We might have multiple subject matters. In most cases, you have to deal with different pieces of legislation, covering different subjects. Well, for example, in work-related activities, you might have to comply with health and safety regulations, you have to comply with the taxation regulations, and so on. And also, we know very well that legislations will change over time, and so this is one of the other aspects. However, when we have this large amount of legislations, then for business owners and citizens, it's very hard to know what are the legal requirements they have to comply in their own business. They are not lawyers, and they want to do their business, and essentially they want to do it according to the legislation, but mostly they don't have a full understanding of what are the legal requirements. So how can we help them? Is it possible to use information technology to help them to reduce their cost of compliance? And this is what we want to do. Now, here I have some figures about compliance. So a few years ago, compliance costs in US, according to the IRS, so the taxation office in US, was approaching $2 trillion per year. In Australia, it was only 250 billion. However, if we compare to the previous year, there was about a 15–20% increase to the previous year. And based on general statistics on OECD countries, in OECD countries, the cost of compliance is between 15 and 20% of the GDP. In Australia, about 9% of the workforce was working in compliance-related areas, and it was one of the fast-growing work area, well, before COVID. Now, let us consider one of the examples why we want to reduce and we want to work in this area. So every year, the Australian government award over 60,000 contracts. The average value for those contracts is $1.5 million. And well, since it's a contract with the government, you have to bid to decide whether the contract is awarded to you, and you have to follow all the strict procurement regulations. Typically, there are 10 bids for every single contract. This means that only one will be the winner, and then only 10% of the participants will win. The other 90%, they are going to do the work for nothing because they are not getting the contract, they don't get the money. And also the procurement requirement could be very, very complex. It could be very time consuming and require specialized knowledge. And most of the time, business, they do not have such knowledge. And if some details are missing, your bid will be discarded without going into the specific content. So can we help them? And this is, again, as I told, it's the key idea behind our work. Now, So we estimated that using digital legislation can help businesses to save up to 30% of compliance costs. Now, if we project on the whole GDP, then this will be about 5% of GDP, which will be absolutely huge. Now, what is the basic idea? What is the idea behind our approach? Well, what we want to do is to have legislation in a dual format. And the legislation should be released in a format that is at the same time human understandable. So subject matter and expert and lawyers and legal experts can understand what are the goals, what are the intent behind a piece of legislation, but at the same time, the legislation should be in a format that is machine understandable. More precisely, it's machine executable. And if it is in a machine executable, then what you can do, you can compute what are the eligibility conditions, what are the obligations enforced in a particular situation, what are the legal requirements you are satisfied given a case. And then this can be done in a matter of seconds by a computer. And it can be also provide an explanation why this is so. So dual representation of the legislation, machine processable and human understandable. So what is the platforms we have in mind for this? Well, the idea is that, well, as you know, the legislation, regulations will be created using the normal democratic process by regulators and policy owners. They will write the legislation. Ideally, we might have some intermediate steps where existing legislation or new legislation written in natural language might be parsed by some machine learning techniques, and then they will be translated into a logical format, in a format that, as I said, is at the same time understandable by humans and processable by machine. And after you have this logical database of the legislation, you can build applications on top. And ideally, the digital format of the legislation will be endorsed by government agencies who have the power, and general bodies who have the power to endorse them and to possibly enact them. So, well, this is the general idea. As I said, we have that the regulators, parliament, they created the legislations. They are stored in a logical database, and hopefully they are released in a normalized language. So essentially, you can have application for interoperability, so they can be processed by multiple parsers and multiple applications. And also you have a set of APIs to consume the legislation, and ideally the legislations in the digital format should be released as open data. After you have that, you can build many applications on top. And here we have just some example of possible application. On one side, you can have, let's say, a tool that provides a logical analysis. So it might identify whether there are some possible loopholes. It can identify what is the red tape. You can identify whether there are redundant clauses in the conditions, so conditions that will never apply, or conditions that are subsumed by other clauses, if there are conflicting conditions, and so on. And then you can build other applications. One of the applications we have in mind, and I'm going to give a few screenshots of it, could be about business process compliance. So you can consider a business process, so the blueprints of how organizations do their processes. And if you have the relevant regulations, you can check for compliance at a click of a button. Then you can do something like what we call Permit Me. So Permit Me could be an application where essentially you have a kind of question answering tool where essentially the system asks some questions to a user. For example, well, what are the requirements to apply for a particular permit? So what are the requirements you have to satisfy if you want to open a restaurant, let's say, in a suburb of Sydney? what kind of permit you have to apply. And then essentially what you have a concierge system where the system will ask you some question about the business and other things. And then depending on your answer, it will refine the question and will add other questions. And at the end of this virtual interview, you will know whether you have all the requirements to apply for a permit, and all the information will be given in the answer of the question, and essentially you can create an application for that permit immediately online. And then since all the answers are provided, it can be reviewed by experts, by people who have the authority to approve in a very simple way. And other applications are possible. And also the private sector and the RegTech industry can create more applications based on their ingenuity and domain knowledge. So what are the key aspects and what are the key benefits? Well, first of all, since we are able to do a proper analysis of the regulations, we can understand possible loopholes and similar, then essentially we can reduce the source of complexity for the legislation, and we can understand, as I said, whether there are some possible problems. Since the legislations will be represented in a computer form, you can interface with other applications and you can determine whether some particular scenarios comply with this particular piece of regulation. And then essentially it will reduce the cost, the general cost of compliance. But also you can create and you can start with a new market-based approach. Now, what are the foundations? What do we need to do? And what do we have to understand if we want to realize this particular vision? And my answer is that, well, machine learning will not help us. What you have to do is just to go back to old-fashioned AI. In particular, you have to go back to old-fashioned symbolic AI. What you have to do, we have to understand how to represent the legislation and how to reason with encoded legislation. And then this is the realm of what we call computational law. So computational law is just be able to provide formal logical models of legislation, where on one side you can determine what normative position, this means obligations, prohibitions, permissions are in force, and when they are in force. And after you determine what are the obligations, prohibitions, and permissions, then you can determine whether a particular scenario, a particular case comply or is in breach of the particular conditions. And all we need to do, all this, it's done in a machine processable, in a machine executable format, and we have to provide the format representation, a model of an underlying normative system. Now, also the key aspect is that we want to have a formal model, a logical representation of a normative system. So we have to understand what is a normative system. So a normative system for us, it will be simply a set of clauses or norms. And those norms will be represented as if-then rules, where we will have that A1 to AN are the antecedent, the if part, so the condition of applicability of a norm, of an article in a code, and C, the then part, it's the conclusion. The conclusion essentially specifies what is the effect of the norm. And then for the effect, we can distinguish two particular types of effects. First of all, we can speak about definitional or constitutive clauses. And essentially, if you look at any legal document, if you look at any contract or at any act, you have a long part which is about the definition of the terms used in that particular document. And essentially, you specify what are the terms in that particular document. The other rules are called prescriptive rules, where the effect is either that something is obligatory, something is permitted, something is a prohibition, but also then after, since we have those notions, we can specify when we have some possible violations, and essentially we can specify what are the possible way to recover or compensate for such violations.
I haven't.
Now, the other aspect we have to consider when we want to create a formal model is that typically norms are divisible. So if you look again at legal document, acts, contracts, what you have is that generally you have a baseline condition, you have a norm that specifies a baseline condition, and then you have long list of exceptions. And sometimes we have even longer list of exceptions with exceptions. In some cases, you might go to another level. You have exception to the exception to the exceptions. You might have even more, but those are very, very rare. And it means that lawyers did their job very properly, because only lawyers will be able to understand the meaning of such norms, and human people, normal people, typically are not. Well, but from a logical point of view, we can do it. Now, as I said, a key aspect is to identify what are obligations, prohibitions, and permissions. And here I just have the definitions we provided in the OASIS legal element standard. So an obligation, a situation, an act, or course of actions where the subject is bounded, and if it's not achieved or performed, we have a violation. A prohibition is very similar, it's just the opposite. So in this case, we have to avoid what is forbidden, but if we're not able to avoid, we have a violation. And then essentially we have permission. Permissions, we consider it the lack of an obligation to the contrary of the lack of a prohibition. Now, key and important aspect, obligations and prohibitions can be violated and violations can be compensated. However, it's not possible to have a violation for permissions. So let's see whether what's said makes sense or not. Just consider this statement here. There's a section, this is section 29 of the Australian National Consumer Credit Protection Act. So when you look here, then what you can see, you have the first subsection, and then the subsections just define the baseline condition. And then this baseline condition specified must not. Actually, this means it's obligatory not. Actually, if you look at the header of the section, the header said prohibition to engage in a credit activity. So when you look here, we can see that here, first of all, we have an explicit if condition. If a person does not hold a license, then the person must not, so there is a prohibition for the person to engage in a credit activity. We can ignore section 2 for the purpose of this talk. It just specifies exactly what is an offense. But then when we start looking at section 3, the subsection 3, then essentially we start to have a list of the possible exceptions. This means that if the condition in 3A holds, and in 3A2, etc., and as I said, we might have a very, very long list. If I remember right, in this case, there are about 5 pages of condition under subsection 3. And then those specify when we have an exception to subsection 1. So essentially, when a person is permitted to engage in a credit activity. Also, it's not important for today, but section 2, in addition to specify what is the offense, it also specify what is the penalty for such an offense. So essentially, what is the compensatory measure in case we have a violation. So how can we represent it? And then what is the idea of digital legislation? So what we do, we want to represent them, as I said, in a formal system that is able to reason with them and to create, to determine what are the obligations, prohibition, etc., in force. And then essentially it's written in a language which is at the same time understandable by human and processable by machine. So here I just have an example of how we can model the previous subsection. So here, as I said, they will be represented by formal rules in a logic. So this is an intermediate language, but it is translated immediately to the language in which they will be executed. So if we assume if Then we have a particular condition, and the condition that somebody is a person. Then we have the conclusion of the effects, and then we have that the credit activity is qualified as forbidden. Then we said, well, we have some particular exceptions, and then we can consider R2. So if the person owns a credit license, then we have that the activity which under R1 it's forbidden, it's not permitted. And then we have some of the conditions specified in subsection 3. Now, what we can do, as we can see, essentially, we cannot have that something is at the same time forbidden and permitted. So what we have to do is to specify the relative strength of between those rules. So what we can specify is that the second rule, R2, overrides R1. So when we have a person that owns a credit license, then essentially we have that both rules R1 and rule 2 files, so we can possibly determine the conclusion, and then we can use this override to say, well, R2 take precedence over R1, so we will use R2, and similar for R3, and so on. So this is just the general idea, and then what I want to do, I just want to go and to show some of the possible applications and how to put them in practice, what I said before. So, well, what I want just to present is just to give you just a quick overview of some of the applications we work in the past few years, and just give an idea of what those applications are for and what we can do with them. So the first one is what we call regulation as a platform, and essentially the regulation as a platform would be the application where we consider the whole architecture, where essentially we are able to write the legislation in the dual format. On one side, we have the natural language representation plus the logical representation. So here, and again, it's not important that you see the details, it's not important. Here, what you can see that we have one possible editor where on one side, in this part here, we have the textual representation, the textual provision, so what it's written in the actual legislation, and then we have the representation of the rules. So one of the important parts and a key aspect of our approach to rule as code in digital legislation is that there is, and as we see with the example before, we see there is a close correspondence between the textual provision and the formal representation. So you can put side by side, and then you can read the formal representation, and essentially you should be able to understand whether there is a close correspondence or similarity between the text in natural language and the formal representation. So domain expert, even with practically no experience in logic, are able to understand whether the intent of the legislation is captured correctly. Also, well, what you can do after you're representing the rules, well, you can create some graphical and visual representation. So here you can see that one possible visual representation is what we call in a kind of a process graph form. So it indicates what are the relationships and what are the steps and informations needed to apply for every rule. So here, all those elements represent some of the condition in the rules. Those will be the conclusion, and essentially the lines represent the connections between the rules. Also, given that particular representation, after we have the formal representation, for example, what we can do, we can go for a different representation. And here, what we can do, we can have what we call the atom coincidence graph. So an atom is just our term and our terminology to specify about what are the conditions. And then here you can see that in this kind of graph, we can show what are the relationships, what are the connections between the different atoms. So the atoms are the terms, the notions appearing inside the piece of regulation. So what we can see, for example, if we look at this atom here, we can see that this atom has many connections. And then this is a tool here. This graphical representation can be used for different purposes. In some cases, you want to see, well, what is the kind of importance of particular atoms. So if you see here, those atoms have a very minimal relations to the other. So this atom here influences only one of the others, while an atom here, it's much more related. So what we can do here is to look at this, and we can have just a visual representation of, well, what are the possible impacts if we do some changes in the legislation. So what about if you want to change the meaning of this legislation here? What are the other terms that are affected by this change of this definition here? And then essentially we can quantify the impact. Also, it is a very useful tool for debugging. Personally, a typo machine. So when I write this piece of legislation, typically there are 2 typos for every atoms. And then, well, I can see immediately, because in most cases, I had some atoms which were completely disconnected from anything else. So there are 2 reasons. Either those atoms are completely useless for the application and there are no other connections, so why do you want to have them? But in my case, mostly was, well, those atoms were just typos and I was using as a debugging tool. But if you're more, let's say, confident about your typing skill, most of the cases you have one of them, it means that atom it's possibly unnecessary. So it might show you reasons to change and to look again at your formalization. The second application is what we call business process compliance. So, well, as I mentioned before, a business process, it's a tool used in, let's say, in management, in process management, and essentially a business process, it's just a graphical representation describing what are the activities, tasks, an organization is going to do in order to achieve a particular business goal. And then also it gives you the order and the possible alternatives for different activities. So this is just an example we did a couple of years ago. It's a business process about how a bank can engage a new customer. And in Australia and in many other countries, when you engage with a new customer, you have to comply with many regulations. In particular, you have to comply with the Know Your Customer KYC regulations. So essentially, the set of requirements you have to satisfy to ensure that it's a customer, it's a genuine customer, you know what is the business of the customer and whether it's reliable or not, and it's not known for being involved, let's say, in some other legal activities. So what we did here, we've modeled the process. So it's a set of activities you have to do, depending on the type of customers, the type of relationships, the type of account they want to open, and many other conditions. We encoded the relevant sections of the anti-money legislation about KYC. And then essentially what we can do, given this process here, what we can do, we can just connect with the relevant regulation. Then we can click a button and we can discover whether the process is compliant or not. So in this situation, we have that the process was not compliant, and the process also described me all the possible ways in which the onboarding of a customer can be done and all different options. And when I check for compliance in this particular situation here, it tells me that there are some problems in this step here, in this step there, and going on. Then, as I said, an important aspect, and also it was highlighted by the presentation by Lilia this morning, it was about, well, when you have a legal decision, you want to know why you've got that legal decision. And here, essentially, if I'm going to tell you, sorry, your business process, your activity, it's not compliant, you want to know why it's not compliant. So here, what we can do, we can examine here. And the idea behind this application is that we simulate all the possible steps. And for every step, we consider what are the obligations, what are the legal requirements you have to satisfy based on the encoded legislation, so on the rules. And then essentially we can see what are the possible violations. And then based on the possible violations, the system in some cases is even able to provide some possible recommendations and to recover, but then a domain expert can really check and then examine and to discover whether the process is actually not compliant. And every time we deal with a legal problem, and in some jurisdiction, for example, in Australia, the only authority that has the power to determine a proper interpretation and to determine whether a situation is compliant or not is the judiciary. So you can always argue up to the judiciary. So essentially it's up to a domain expert or a legal expert to determine whether the situation is really non-compliant or not. So in this case, in most cases for administrative purposes, probably you can trust the tool, but it's up then to the organization to discover whether the situation is not compliant or not and how to address it. Now, the final application is just to demonstrate what we can do in some other areas. And this is just one of the other different editors we created to have at the same time the legislation in natural language and in the formal language. And essentially what we did, we look at Section 7 of the Australian Crime Code. Section 7 of the Australian Crime Code, it's about what it's called spent conviction. Spent convictions is the discipline regulated when a person is entitled or has the obligation to disclose information about previous convictions. And so, for example, if you want to apply to a new job, they might require you to do a police check. And essentially, in that application, you have to, for some particular type of jobs, you have to disclose previous convictions. And the federal scheme, the Australian federal scheme, gives you the conditions when you are allowed to give the information, when it's forbidden for a party to ask you the information, but also when some parties are permitted to obtain information from other possible parties here. So we encoded part 7, which is about this, and then essentially what we can do, we can provide a particular case. So if you look in the central pane here, you have the information of the case. So we have, well, what about on September 2019, we examine a case, and this case that a person A, let's say A, well, declared that it was convicted, has a conviction. The convictions was back in 98. The convictions was for insider trading. Insider trading, it's in Australia a Commonwealth offense, given that it's covered by Division 10 of the Corporation Act. However, that person was discharged with a 2 years good conduct box, so the person was not in prison, and then it was now it's seeking to work for the Australian Federal Police as an external consultant. So the question is, well, what are the requirements for A? Does A have to disclose that it was convicted back in 1998? So the general schema is then if a person is an adult and a crime, it's a minor crime. So there is the definition of what is a minor crime, but the convictions was older than 10 years. Typically, the person is entitled, is permitted not to disclose the information. However, if a person wants to work for, let's say, a federal agency or a police or a law enforcement agency or other conditions, then they have to disclose the information if it was older than 10 years. So what we can do, we can just give this case, we can click a button, and just to be sure, I just have this screenshot here. It will take less than a second. It will take probably 1/10 of a second just to provide the answer. and then it gives you the information. So here we have it that we have obligation disclosed. This is the symbol for obligation. It has to disclose that it was charged. It has to disclose that it was convicted. And also other entities that are aware about the convictions are permitted to disclose that it was charged and convicted. And then also we will get other condition. And here the key point, it was, yes, the waiting period was ended. So the convictions was older than 10 years, but it's going to work for a law enforcement agency. And then essentially this is a tool that, well, we were considering for the Australian Crime Commission, and they run the National Police Check Service, and every year they examine 6.5 million cases manually, and based on our experiment, we evaluated that 80–90% of the cases can be assessed accurately by the tool. We evaluated, so we ran a small number of cases. We had a small number of, we had 3 judges look at some of those cases, and we had 100% accuracy. So it's not really, it's just an anecdote. It doesn't have any statistical significance. However, we got perfect score. So we are able to estimate that we were able to do 80% of the cases correctly. Okay, so that was the end of my presentation, and I'm open for your question, and thank you for your attendance so far.
Thank you very much for the wonderful and intriguing talk. So we do have some questions. Mr. Rajeshwari Sridhar has 2 questions. The first one is, when you say old-fashioned AI, have you decided any specific representation for representing legal data and basically devised special inference rules for the same?
Yes, absolutely. We've been working on this aspect for a long time. So I would say we have over 20 years of work in this area. So old-fashioned AI for me, it's just a symbolic representation. So essentially not machine learning. And for the representations, we have created our language and we have created our logic. And also I just gave the example, the spent convictions and all the tools we created, they use our logic and our implementation of the logic on the background. So we tested against several cases. So in the spent conviction, it was based on a very small number of cases. We did some other experiments where we evaluated from the theoretical point of view the accuracy of our system. Well, a few years ago, I was working with some colleagues in Japan, and we were just working on that, and we were looking at some examples from the Japanese civil code, and we were given some, and my colleague gave me some 10 questions from the Japanese bar exam. So I encoded, I look at the cases, and in 9 of those cases, I get exactly the answer given in textbooks and in the bar exam. For the 10 case, that was an interesting situation because it was debated by textbooks about what was the proper solution. So I cannot tell you whether my solution was right or wrong because there was debate on scholars on the textbook. And in any case, we can possibly tweak one parameter in our reasoner to get both solutions. So we were doing. More recently, we've done an experiment in collaborations with the Queensland University of Technology, where we did some large-scale encoding of different pieces of legislation, of federal legislation in Australia. And also we look at those examples from the Australian modern interpretation theory. As I said, the only definite answer whether the encoding is correct or not in Australia can be only given by the judiciary. However, based on past cases and interpretation and discussion of textbooks, we have a proper evaluation. It seems that we are conform or we are aligned with the prevalent interpretation of those cases.
Okay, thank you. Thank you. So I have another question with regard to the diagram which you showed, which consisted of multiple atoms. So the question is, in the regulation as a platform project, how do you establish the link between multiple atoms?
Okay, now I showed two different types of graphs. The first, essentially the connections are given by the structure of the rules. So as I said, the rules have an if-then structure. So essentially there is an arc between one atom to the other, whether one atom is the antecedent of a rule and the other atom is in the conclusion of the rule. So essentially this is the, and then of course, we propagate. So we don't have the transitive closure, but essentially the graph is built in this way. When we look at the what I call the process graph, essentially that graph gives us a spaghetti representation of the rule themselves. So all the steps, all the antecedent of the rules, and eventually, if I have to concatenate multiple rules, I can show there. In the second graph, it just gives me the direct links between the atoms based on the if-then structure.
I see. Thank you. Since we have some more time, maybe we can take some more questions.
Yes, absolutely.
Yeah. So, so that was the second question by Mrs. Rajeshwari Sridhar. I have another question from Rinkaj Goyal. The question is, are social network analysis techniques used for the complex network of the rules thus prepared? Moreover, is such a framework within bracket and regulation as a platform available in open source?
Okay, for the first part of the question, no, we don't do social network analysis. In general, we don't do network analysis on the rules simply because we take the rules as they appear. The rules correspond to the conversion from textual provision as given in a statutory document, so in a contract or in an act and so on. Maybe some network analysis can be interesting. There might be some other applications to possibly to understand some other aspects, but we haven't done it. And actually, if there are some ideas on how to use it and what would be the possible users, more welcome to look at them. We didn't do because for what were our purposes, we didn't see an application. I can see some applications if you want to understand possibly well how important a particular norm is in a particular normative system. This is it's a valid argument, but it wasn't our purpose, so we didn't do that work there. Now, for the second part about whether the tools and the framework is available as open source, the answer is ideally yes, we were working on that, but there were many buts. It was just a prototype, and while several parts of the prototypes are commercial grade and industry grade, the full framework at this moment doesn't meet that requirement, and there were some other aspects to be addressed. There is one reasoner which is available as open source. It's called Spindle, and if you Google for Spindle, Nicta, or Data61, you are able to find it, and it's open source. It's available. The other tools, there were some of them might be released as open source soon. Others, they were just internal prototypes. So it depends. So my answer is very lawyerish, so it depends. As any good lawyer will say, the answer is always it depends.
Right. Thank you. I have a question from Rahul Bishnoi. The question is, what can be said for the biasness in the data of precedence itself used by the symbolic AI, for example, racial bias?
That it's about establishing what are the precedent and what are the facts of a particular case. After you give the facts, the bias is in establishing the facts. After you have given the facts, there is no bias whatsoever in the symbolic representation. The symbolic representation is meant to correspond to the rule of law as it is written. So there will not be bias in that aspect. So how you establish a fact, whether you want to use some machine learning techniques, etc. Yes, there will be some bias there. And for us, it's, well, unfortunately is, well, garbage in, garbage out. So if you provide me biased data in the case of a factor, unfortunately, I cannot do anything. However, that is the other aspect. So yes, there is definitely room for machine learning and determining biases, but that it will be about the fact of a particular case. After, the reasoning is completely transparent, and for every step, you can identify what are the article of the law that you use to derive a particular conclusion. So in that campaign, it will be completely transparent, and the bias will be on how to get the data from any data set you have.
Okay. So someone raised her hand. So I would request person or any other person who would have some question to type their questions in Q&A, because that's the mode we are following. So the next question is from Harsha R. The question is, do you think computational law must be a part of law school course? I'm not sure which country is talking about. Is it
Okay,
a part of
yeah.
in Australia or Italy, for example?
As for what I know, at this moment, it's not thought in let's say, in law schools, or if it's done as a very, let's say, exoteric subjects. 2 years ago, I gave part of a course on this topic at the University of Queensland. We are considering, I'm working with some colleagues in a couple of universities to create some courses and to give and to have an introductory courses for law students. So, well, there will be one course at the University of Bologna in 2022. It should be first, well, it will be from, okay, in Italy, it will be the second semester. So it should be from January, February to June 2022. That courses will be offered. I'm working with some Australian university to develop and to prepare some of those courses in some law faculties. So absolutely, yes. And of course, it could not be different from me. The interesting part is that, well, we did a project with, as I said, the project I mentioned before with my colleague from the law school at the university, at the Queensland University of Technology. And what was interesting is then law student, after a few sessions of training, they were able to encode without major problems.
Okay, thank you very much. So the next question, so can have maybe 5 more minutes. So someone asked a very technical question. In your application, which embedding method is used and which data set the embedding vector is trained on?
Okay, to embed data, we use different techniques. No, we don't use vectors, so we don't use any machine learning for us. So essentially, what we did is we just get the case, and those cases are given. We work on a couple of applications to demonstrate some of our technology. And what we were doing is we created some interfaces between our reasoner, the logical reasoner, and relational databases. So the relational databases will provide the case data. One of the experiments we did was about with FDA regulations about adverse effect. So essentially, what are the requirements? What kind of information you have to report when there is an adverse effect against some drugs? And we were able to do that, and just doing kind of brute force approach with no optimization, etc., we were able to examine 4.5 million records in about 8 hours. We've developed some additional techniques to speed up, and then it should be possible to process, let's say, 1/4 of data, 1/4 of a year of data from FDA in about 15-20 minutes if you use some additional techniques. But yeah, we don't use any machine learning. The technique was just to run some SQL queries on the database plus optimization on top.
Okay, thank you very much. So I think we can take one more question because that's the last question which I have on the plate. So is RAAP, so R caps, A in small and P in caps, being used by any law corporate institutions at present? If yes, is it being cross-checked by the experts all the time? It is given out verdicts, or can you rely on it fully when the cases are simple?
So what we did, let's say, being used by any law corporate institute, probably the use, it's a very strong word. So we did experiments. So we did at least 3 industry scale experiments. The first one was on business process compliance, where we encoded one of the chapters about the Telecommunications Consumer Protections Code, and we checked for compliance of one telco. And essentially, we give the answer to the domain expert, who were also involved in writing the regulation. And the interesting part, essentially, we identified many aspects where they were not compliant. And also they were able to check and they say, yes, all those aspects are true, and we are not compliant with that. So it was done in that way. Then we did the other experiment. The other experiment was the spent conviction. The spent convictions was encoded manually. It was lightly checked by some of my colleagues at La Trobe University. And then essentially we tested again a few small number of cases. And then essentially we asked some judges and ex-judges about the answer and whether we got the final one. The final aspect, it was the recent project with QT, which was done in collaboration with the law school at QT. And essentially that it was checked by my colleague at QT for correspondence between the text and the Australian modern interpretation. So there was something. The ideas behind the rule of code is that the rules are released, but then those rules should be endorsed, but whoever is going to answer to use them. So the idea is, and you might have different levels. So you can check the rules, you can run test cases and similar. So you can apply, let's say, software engineering techniques to ensure quality. But at the end, if the rules are developed by, let's say, a private company, the private company should sign off their own regulation. If they are released by a government agency, then it will be the government agency's responsibility to check and to do some tests.
All right. So I have one more question. I think this has been, addressed before. So the question is by Divya Dwivedi. Do you think that there may be gender bias with AI as well? Told that bias are almost completely done away with, right?
Well, for us, there is no gender bias. So if this is a general question, I would say possibly yes. If I have to speak about our application, I don't see there will not be bias in our tool. In particular, there will be no gender bias in the tool simply because it's just based on a logical representation, and it will not be possible. Well, if you want, you can add bias on top, but essentially you have to write rules to be biased themselves. So essentially you have to write in a different way. And the bias will be mostly if it is already in the piece of legislation you are going to convert.
Okay, thank you very much. So I don't see any more questions. So let's thank the speaker once again for the wonderful talk and taking pains to answer to all the questions asked by the audience. So thank you very much. Thank you very much.
Thank you very much for this opportunity. Thank you.